How you own your assets can have a great impact on your plan and your family later, especially if you decide to commingle assets with outside family members. I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. We provide peace of mind to families through our high client value services. If you are seeking assistance in estate planning or probate or trust administration in New York or New Jersey, you can reach out to us for a free consultation at yourplanningattorney.com. And we're always here educating for free as well, so please ask questions and be sure to share so that we can help some folks together along the way. So I just had this come up in a prospective client meeting. I also had this come up as a viewer question. How do you sort of disengage from this joint relationship with real property when you and, say, a child or you and a sibling own real property because you were helping that person out without having maybe a tax impact, and of course trying to preserve your own family dynamic and planning so that those complexities are no longer a part of the big picture. So the question we actually got asked was with regard to a woman and her brother, and she was seeking, advice on how to transition this property, minimize tax consequences, and of course, protect the relationship with her husband, who wants to make sure they're clean and clear of this other property, right? This is not an uncommon situation. It does happen. Sometimes, again, with a parent and a child when they're starting out and they're trying to help them. Part of the situation does come down to the specific variables, like who has contributed what amount, right? In this scenario, I think the sister had contributed some money to a down payment, but the brother who lives there has been paying all of the bills, and I believe the mortgage payments as well. And it's not the primary home of the sister who is trying to distance herself. So how does she take care of that without having a huge impact tax-wise? I'm so sorry. Oh, that's so rude. I apologize. It happens. Okay, and it's a little late right now. So gifting to the property, which I don't think is a consideration in this situation, just transitions the cost in the property over to the brother, right? And then he would deal with any capital gains later. But that doesn't necessarily recoup the sister's contribution into that property. Even if she sells it partially, maybe below market value on her portion to her brother, it still is going to be a partial gift, and that could impact the brother down the line. The sister won't get fully reimbursed. And then the remainder, if you did it at fair market value, or you did so you transitioned your 50%, but you only gifted 25 and he repaid you for 25. Well, you might have some capital gains consequence depending on how much growth there was in the property relative to that 25%. You can also gift it with the mortgage. This is a little trickier. Most banks don't like someone, coming off the mortgage. They won't allow it, a person to assume the mortgage unless they're able. And attempting to transition it without sort of the bank approval could certainly trigger the due on sale clause under the mortgage, meaning they're going to want full payment right away. So, and I think beyond the sort of financial picture and cleaning up your asset makeup for your own family is the sort of emotional bend on this, where if your spouse is concerned with it, it just, cleans things up in that realm as well in your relationship, to have clarity on the title, who's going to be liable for the mortgage, and all of that. One really suggested strategy is selling it for fair market value. So if you are and this is tricky because sometimes I find real estate attorneys, even if the sister contributed, a quarter of the down payment, right? And was there as sort of a financial backer on the mortgage and has not paid a penny since. Well, the deed sometimes shows up as 50-50 ownership, right? And that doesn't really make sense because that's not how it was intended. And that was actually true, I believe, in the circumstance with a prospective client. It was a mother-daughter situation. So you have to be mindful of what the actual contribution was, and a sale at the fair market value for that percentage of your actual interest may not have that much of a tax impact. But if we're talking about a 50-50 ownership, you sell it at the fair market value, and if your brother can't repay that, pay you that right now, you hold a note, you hold a mortgage for him. And you can structure it in such a way that it's like paid in installments, which would kind of drag out the capital gains that you would have to pay over time. Presumably, one, maybe making them a lower capital gains rate. And obviously, the more you can delay the payment, the better off you are. You could also, again, depending on your family circumstance and your intention with your brother and your own family, you could forgive some of that debt based on the annual gift exclusion. So that would avoid having to file a gift tax return. Like in the other scenarios, if you really just gifted, property outright, you'd have to file a gift tax return. But here, if you sell it for fair market value, hold a note, which would have to be at appropriate interest rates, by the way, even if it's a family member, or more so when it's a family member. The government looks into that. You can't have it below a certain threshold, or that they will almost force the interest rate to be a certain threshold. So selling it at fair market value may still have that capital gains impact, but if you structure it the right way, you might be able to spread it out over some years. And I think in this scenario, the brother had a life insurance policy to basically cover the remaining mortgage, or maybe it was a repayment for the sister. I'm not exactly sure. And it's helpful, but that may never come to fruition if, God forbid, you predecease your brother, right? Like how does that work? It's not very clean. So my suggestion is, when it comes to assets that are commingled with parties sort of outside your bubble of estate planning, protected people, spouse, children, grandchildren, whatever your bubble is, if your plan has assets, and even it could be with one of those people, but if your asset structure is tied to somebody else outside of your immediate people right now, maybe not the beneficiaries later, then you want to clean that up and have a proper allocation of the ownership based on the payments and the intent in the future. Even if there is gifting that needs to be done, do it properly. If there's buyouts that need to be done, do it properly. And seek assistance. This is what estate planning attorneys should be partially there for, is to guide you to make sure your assets are clean, they're clear, everybody knows what they are, how they're titled, how they should be distributed later and handled. Truly, your estate plan is supposed to be your, peace of mind plan. So make sure if you have these types of assets, you do so. We hope you've learned something new here today. You can always reach us at yourplanningattorney.com if you need estate planning or administration needs in New York or New Jersey. Thank you so much for listening. Take care, and don't forget to share.